Okay, well, good morning, everybody. My name's Gene Colters, presiding member for today's Metropolitan Outer Development Assessment Panel meeting. I'll declare the meeting open at 9:34 a.m. and in doing so, I acknowledge we're hosting this meeting on the traditional land of the Whadjuk people of the Noongar Nation. We acknowledge the Aboriginal people as the traditional custodians of Western Australia, pay respect to elders past and present, and the ongoing connection between people, land, waters and community. This meeting will be run in accordance with DAP Standing Orders 2024 under the Planning and Development Assessment Panel's regulations of 2011. The meeting is being recorded and live streamed on the DAP website in accordance with Regulation 42A of the Planning and Development Assessment Panel's regulation. Members are reminded to announce their name and title prior to speaking. During the meeting, panel members will refer to or may refer to technical devices to assist them in considering the information before them. I'll introduce the members present. As I said, my name's Gene Colthouse, presiding member. On my left, Karen Hyde, deputy presiding member, and to her left, Heidi Herget, specialist member. Online, we have Councillor Jackie Humphrey and Councillor Sonnet Coetzee from the City of Wanneroo. Item 2 on the agenda is apologies from Councillor Bronwyn Smith from the City of Wanneroo. Item 3, members of leave of absence, there are none. And item 4, we note minutes of previous meetings, they are on the DAP website. Part B of the agenda is the City of Wanneroo application, and the first item is I'll ask confirm all panel members have duly considered all the documentation within Part B of the agenda and Part B related information. If you'd raise your hand to confirm that, please. That's unanimous, thank you. Disclosures of interest, we have none at this stage. Councillors, was the application considered at a council meeting at all?
No, this one wasn't, but the original, I do believe the original area was considered to change it from urban to a commercial. I think, Karen, you were on that JDAP when that was done. Yeah.
Okay. All right, well, that's fine. Item 3 on the agenda, we go into the actual item, the proposed service station, motor vehicle and dog wash at Lot 2, Butler Boulevard, Butler. We do have 4 presentations at the meeting, and I will start off by reminding all presenters that you have 3-minute time frame. First presenter, Nada Raphael, and I think Sandra Eckert, both from Minter Ellison. You're doing separate presentations.
Correct.
3 minutes each. Thank you. Nada first.
Great. Thank you, presiding member. We act for the owner of Lot 4 who opposes this application, and I'll make 3 primary points. My first point is that the proposed development includes development on Lot 4, and our client has not signed the development application nor consented to it. Under the deed provisions, it's a mandatory requirement that a development application includes the signature of each owner of land on which the development is to be undertaken. Without our client's consent, the development application is invalid and the DAP has no power to approve the proposed development. By condition 3, the city has attempted to cure the invalid development application by excluding Lot 4 from the application and the physical works from its assessment. Has already been acted on. The Supreme Court and the Tribunal have held that once a development approval has been acted upon, it remains binding on the world until it is amended by the grant of a further approval. As a matter of law, it is not permissible to rely on 2 approvals in relation to the same land when those approvals are inconsistent with each other. So the granting of an approval for the service station with substantial crossovers onto Clayton Street would be inconsistent with the Lot 4 approval, which requires a provision of 9 parking bays over the same area. Our client has not made an application to amend its development approval, and our client's approval cannot be unilaterally amended by an adjoining landowner. And I'd like to draw the panel's attention to the approved development plans at paragraph 2.6 of our submissions, in particular the second plan that's labelled attachment 3A. And on that you can see that there are parking bays located within the east to west connector to the north of lot 2. And there has been no assessment that's been undertaken in relation to the consequences of removing those parking bays. There's also been no assessment undertaken in relation to the movement of the fuel tankers through the easement area that's been approved under the Lot 4 approval. In particular, how will these fuel tankers exit this precinct? Surely not through the town square that consists of multiple pedestrian crossings. If the tankers are going to turn north on the main street, is it even possible for them to take that bend? The technical reports are simply silent on these matters. Will there be other modifications that are required to our client's land that are proposed to be undertaken without our client's consent? So to summarise my point, the service station on Lot 2 with crossovers into Clayton Street conflicts with the Lot 4 approval, and the Lot 4 approval cannot be amended without our client's consent and a proper planning assessment. To do otherwise would offend the most fundamental principles of planning law. My last point is that the development of the crossovers onto Clayton Street are a central aspect of this application and cannot be divorced from the service station. The ability for these fuel tankers to access and refill the service station from Lot 4 is absolutely necessary for this use to function. With all due respect to Mr. Hodgkin, he appears to have misconstrued the works and the extent of those works. It is not just one crossover, it is not just one car bay as he suggests in his correspondence. This is more substantial. It involves an 11 metre to 11 metre wide crossovers. It involves the removal of 7 parking bays, a footpath, curbing, a street tree, all of which were constructed in accordance with the DAP's approval for the shopping centre. In our view, these are works requiring development approval and our client's consent. The city's officers have agreed with that position. This case can be distinguished from the Puma matter, which has been referred to in the submission by Mr. Skinner, because that did not involve necessarily physical works. That was just an intensification of a use, and an intensification of a use does not require owner's consent, but owner's consent is required where there are physical works that are being undertaken on our client's land. It's respectfully submitted that the DAP has no power to approve this development without our client's consent, and it must be refused.
Thank you very much, Nada. We'll wait till we get Sandra's presentation as well. Thank you.
Thank you, Presiding Member. I'd also like to make 3 further points in relation to the operation of the easement. The first one is that this is not a public road, it is a public access easement. A public access easement does not displace ownership of the underlying land. Lot 4 is owned by our client who retains rights and liabilities in relation to it. The public access easement covers a very large proportion of Lot 4. It includes not only Clayton Street, but all of the areas external to the shopping centre buildings, as are highlighted in green on the deposited plan at Annexure C of our submissions. It cannot have been the intention of the parties that the Lot 4 owner would give the city an unfettered right to control what happens on such a large portion of Lot 4, which is the effect of Mr. Hodgkin's submissions. The second point is that the public access easement must be construed by reference to its express terms and by reference to the statutory provision under which it was created. The easement was created under sections 195 and 196 of the Land Administration Act to comply with the conditions of approval granted under the Planning and Development Act. As a member of the public, the Lot 2 owner has a right to access Clayton Street, but that right of access does not mean that as an owner of an adjoining lot, it is entitled as of right to construct a crossover or crossovers from its lot at any point along Clayton Street. The easement also grants the city and otherwise authorised persons such as customers and visitors to the shopping centre the right to park in bays marked for that purpose over and along the public access area. The location of the parking bays are depicted on the development approval granted by the DAP for the shopping centre. There are 9 bays and a footpath constructed in accordance with that development approval along the northern boundary of Lot 2. Under the terms of the easement, the right of access, which is for both pedestrians and vehicles, and the right to park must be read together. Reading the easement's terms as a whole, vehicular access from Lot 2 onto Clayton Street is prohibited by virtue of the location of those marked parking bays, which are required under the easement and cannot be removed without our client's consent. Vehicular access to the road network from Lot 2 is available over other adjoining parts of the access easement. It is not landlocked. It is just not suitable land for this proposed development. My final point is that the city simply does not have the power under the easement to approve works on Lot 4 without the owner's consent. The city is not an agent of Lot 4 owner. An agent must be appointed in writing to deal with interests in land, and the city is not appointed as an agent of Lot 4 owner in the easement or in any other document. The further assurances provisions in clauses 3.4 and 6.2 do not have the effect of appointing the city as our client's agent to sign the development application, nor do they require our client to consent to any works or permit the crossovers to be constructed. Contrary to Mr. Hodgkin's submissions, nothing in the terms of the easement suggests that our client has conferred on the city an authority to determine what works are permitted to be undertaken on the easement in a manner contradicting our client's development approval. The purpose of the easement is to facilitate both access and parking to the public. This part of the easement area contains marked parking bays and a footpath to fulfil that purpose. In this instance, the right of access from Lot 2 onto Clayton Street is limited by the right granted to the city and all members of the public to park in the marked bays that have been constructed along the northern boundary of Lot 2 in accordance with the approved plans that gave rise to the easement. Again, it is respectfully submitted that the DAP has no power to approve this development and it must be refused. We would be pleased to answer any questions from the panel.
Thank you. Moves into questions of the presenters. Councillors, do you have any questions of the presenters at this stage?
Thank you, Presiding Member. Could I ask, so ultimately, Lot 4 is not going to give any access rights to this development, is that correct?
Our client has not consented to provide access, no.
Not at this stage.
Not at this stage.
Yeah.
There have been some discussions, but our client has not consented.
Does that answer your question, Councillor?
Not really. Would he? Is there a negotiation to consent or not?
Not at this stage, no. Well, our client has considered this further and considered their development approval and the impacts that it will have on its development approval,
Sure.
and has not made an application to amend that development approval. There were some early discussions, but then the application was lodged without our client's consent or its knowledge, which took our client by surprise given those early discussions. And so at this point in time, it is not consenting to this development.
Okay. Any other questions from panel members?
Just a quick one to get some confirmation. There's a Dan Murphy's on the northeast corner of Camborne and Butler, okay, which obviously was built some time back. Its primary heavy vehicle access is afforded via what's nominally known as Clayton Street, but it's not a public road, it's presumably to get their trucks in and out, that is actually the only way to do it because of the way the loading dock is located. They would have had to actually negotiate with that particular landowner to allow access into that right of easement.
Yeah, so I don't have instructions on who gave that access. Obviously, our client purchased this land a few years ago. It was previously owned by Woolworths.
Yeah,
so to the extent the Woolworths provided that right of access, it may have consented under an agreement in
So
place.
my question is, they obviously do have a legal right of access to access that remnant part of Lot 4, which is Clayton Street.
Assuming that an approval was granted for that access, yes.
If I might also, the
Yes.
public access does cover that area. I'm not sure, just bear with me.
The access easement shown on the attachments on the deposited plan or the strata plan doesn't include the Woolworths area at all, does it? That's the bit shaded green.
It shows part of it in the terms of that access down there, but not the access in there. So part of it is got covered by the public access easement.
Yeah, I'm talking specifically about the Dan Murphy, so I don't know whether it is on your DP.
It's the same, it's this lot down,
Yeah, correct.
this area down there.
So forgive me, Dan Murphy's does not front Clayton Street.
No, but it's got access via lot 101 to directly to Clayton Street.
So through the crossover on the plan or through another?
Through the crossover.
Oh,
their
right, yes,
plan.
that crossover was approved.
That was my
right,
question.
that's part of the original development
That's fine.
approval.
Okay.
So there hasn't been additional approvals granted
No.
for the removal of parking or anything to allow access.
So that's
So
fine.
forgive me, I wasn't sure whether Dan Murphy's was on the
Thank you.
plan.
So if I might just correct, sorry, I had the plan upside down. This lot down here, which includes Dan Murphy's, does have the public access easement is also partly, or is also over part of that lot as well. So that area there, which does not appear to be all of the Dan Murphy's area, but just looking at that, there is, when the public access easement was originally granted, it was granted over that area as well. We only highlighted it for the purposes of what is now lot 4, but the original grant of the public access easement was over a larger area, and I understand remains over a larger area, including parts of this lot as well.
Thank you.
Thank you. Yes, Karen.
Thank you. Just to follow on from that previous question, and again, looking at your green plan, there is a further right of access, presumably again granted to the public, to the east of lot 2, which again has a crossover from what's referred to in these plans as the east-west connector, otherwise Clayton Street.
Correct.
There's no dispute about those
No.
2 particular crossovers and the right of access from those crossovers to lot 2.
No,
So that could be a situation where lot 2 could access from either of those crossovers.
absolutely.
So,
There's no dispute in relation to those 2 crossovers, which are very.
and the crossover to the west, which at the moment provides access to Dan Murphy's.
Lot 101.
Yeah, is that exclusive to Dan Murphy's? Is that part of the general public right of access?
So
No.
we don't know.
That was part of the original grant of the public access
Yeah.
easement. So assuming, when we haven't done forensic analysis of what's left on that lot, but assuming that has not been surrendered, that public access easement goes to that crossover.
Yes, thank you.
And it is it is part of the original public access
Okay,
easement.
so we could assume that we have public access either side of lot 2 from Clayton Street, potentially. And so it's not solely the southern access from Butler Avenue that provides access to lot 2.
That's what it appears on the plans, but I don't know from a practical perspective whether there are bollards or anything else in relation to the
I
car
can ask
parking.
other questions
Yes.
in relation to that. Thank you for that answer. If I may have got some more
Go ahead.
questions. So just trying to narrow down what your objections actually are. Having read all of your documentation, we did seem to go around and about a fair bit. Your issue seems to narrow down to the, should we call them the new crossovers pertinent to this development application, which interrupt the parallel parking, a tree. I have to say it's not in great shape, the tree. But can we assume you have no objection to the land uses? You didn't mention the land uses in your submissions. You talk very generally about development, but the development that you're referring to, I take to be the development that you perceive to be on lot 4, rather than the development per se, which is on lot 2.
So, I mean, our client does object to the development on lot 2 in the sense that of the fuel tankers moving through the easement area.
That's not my question. My question is, I couldn't determine from your objection that your client objected to a D and an A use occurring on this lot. Your objection seemed to be more how that lot was accessed.
Our submission relates to the power to actually approve it when there is no access. And access, as you know, is a key consideration under the deemed provisions. And so if there is no access for this specific use at this site, and our submission is simply that the fuel tankers require access through these two crossovers that they're proposing to construct, the traffic impact assessment clearly states that the swept paths must occur through these two 11-metre crossovers, and they simply cannot occur without our client's consent and amendment to our client's development approval and a proper assessment.
To this point, your client has not objected to the actual use classes proposed. It's more the access and the function of that access.
Well, we need to seek instructions on that, but we just thought that it would not even get to that point, quite frankly, because this application should never have been accepted for assessment.
Okay. One other question, if I may.
Go ahead.
In the applicants' submissions and their application for the development, and I think you alluded to the fact that there have been negotiations in the past regarding a signature, if we will, or a
Consent, yes.
a consent. Why in recent months has that not been forthcoming when conversations obviously started last year?
So conversations started last year, and there were a number of conditions that were imposed on any potential consent that may be provided, which always required further discussions and further consideration of the matter. We did not hear further from the applicant's solicitors, and our client was not aware that an application for development approval had been lodged. We were understanding that they were awaiting further discussions with us. Our client missed the objection period, not because we're trying to get to the bottom of who the notice was actually sent to. It was definitely not, our firm was not alerted to a development application being lodged, and our instructors at Charter Hall were not aware that a development application had been lodged. So during that period, our client did not object, and we didn't obviously have the opportunity to, after that closing, submissions closed. After that period of time, they were asking our client to consent, and at that point in time, obviously negotiations had broken down.
All right. Okay, thank you.
I'll just jump in.
Mm-hmm.
You mentioned conditions on the negotiations. Was your client aware of the uses? Service station, car wash, dog wash during that period of discussions?
They were aware of the uses, but it was more about what condition, what sort of agreement would be entered into.
Commercial considerations, which we don't need to know about, but
yes, correct. It's not a relevant consideration for MODAP to consider what those discussions were.
And we're not asking, I'm just asking about the uses, as a member Hyde had mentioned.
Yes, so our client does not consent to the uses without further discussions in relation to what might be arranged in relation to them.
Okay, thank you. I do have some questions. Under the terms of the easement, the access includes access for vehicles. Okay. Given that when the access arranged or the easement was set up, the land uses proposed on that portion of the site were generic?
I think it was retail and commercial at the time.
Generic,
yes.
You don't know what sort of retail, you don't know what sort of commercial, but the zoning permitted service station, car wash and so forth. So one would contemplate that those uses could be applied for?
Well, they could be applied for, provided that they had appropriate access to the site.
They do have access in terms of for vehicles. I'm asking the question. They have access to uses, discretionary or permissible, on that site. So vehicles can enter and leave the site?
they can
Under the
access,
terms of the access easement?
they can access through those two crossovers that were identified on the plans, and they can access through Butler Boulevard to the south.
Which crossovers are we talking about that are identified on the plan?
So if you look at the plan on attachment
It's
3A,
either side,
correct, either side.
but not directly off of Clayton Street?
No, so, well,
What
they
would-
are off
What would
Clayton Street.
preclude that?
So there are parking bays that are actually alongside the north
Well,
of
the
boundary.
applicants are arguing that you would anticipate that you could get access through.
Yes, but you must review the easement as a whole. The easement refers, and I can take you to the provisions, it refers to an access easement and a parking easement.
Does
This-
it restrict it from Clayton Street? Does it say no access by vehicles from Clayton Street?
No, but it needs to be read based on how that easement was, how that easement came about. That easement came about by virtue of a condition on a development approval.
Yep.
That condition of the development approval showed access points and it showed parking. The easement document that was then prepared refers to both access and parking. The parking can be shown on the plans, and there are 9 bays to the northern boundary of lot 2.
Yeah, I get that.
So you cannot access by vehicle from those points. This easement is for the purpose of not just vehicles, it's also for pedestrians.
Yes, I
So
get that.
as you can see, what was intended for this east-west connector originally was a bit more of a main street sort of design, where you would have buildings there and the public could access, you know, retail or commercial uses by foot. They could park their car there and then access the relevant buildings. So that was
All right,
what was
I-
intended. And so unless the approval is amended, which was granted by the DAP,
You mentioned,
and,
yes.
and a proper assessment is undertaken about what happens if those parking bays are removed. There's been no assessment into that.
Right.
And there's also been no assessment into the intensification of the easement area by these fuel tankers.
Okay. All right, yes, you've got a
Just one
question?
follow through.
Mm.
Knowing the area, would you accept that there are different characteristics to the western side of what you're referring to as Main Street, otherwise the east-west connector, versus the character on the eastern side? My impression of the western side is that it is very much big box, bulky good retail. It's car dominated. It's not the sort of place that you would go with your little shopping bag to buy things necessarily. So the notion of it becoming similar to the character to the east of the north-south connector, which is clearly of a finer grain,
Yes,
much
Councillor.
more diverse retail offering.
Yes.
One could say that ship sailed long ago. This is now very much more akin to an Osborne Park or an O'Connor in its nature.
Yes, but if you look at the northern site, which was developed, there is no street access from those bulky buildings that were constructed there. So the auto
Yes.
shop, the access is from internal, from
Yes.
the car parking. So this street is sort of preserved for pedestrian sort of walkway
But in
towards the town
In
square.
the same way,
Mm.
you know, sadly, that puts the activation to the car park side rather than to
Yes.
the pedestrian footpath side. So in looking for uses that may actually activate and provide some level of passive surveillance, the only opportunities for that now remain actually on the southern side. Would you agree with that?
Well, I think that's a question for a planner, but
Okay,
but
all
there's
right, well, I'll
no.
refer to the planners then.
Yeah.
Thank you very much.
Okay, thank you very much. Well, thank you for your presentations. It was enlightening. We now have a changeover, and Tanya and Mr. Skinner doing their presentations. Panel members, at any stage, we can go back to the two presenters if we need clarification on any items. If you could do your presentations and then we'll do the questions after. Thanks very much.
Great, thank you very much, Presiding Member. Sounds perfect. Let's get myself set up here. Thank you very much. Good morning, planning member panel members. I'm the applicant of the commercial development proposed at 125 Public Boulevard. Of course, joined by Julia Skinner of Thompson Gear, who is also presenting support. Just generally as an overview, the city's RAR is generally well prepared and articulates sound reasoning for the approval of this development. Obviously, we're seeking to challenge condition 2 that was outlined in our presentation materials. There are some legal reasons behind this, and it relates very closely to the public access easement and how that's been drafted in the sense of the site. Given that's the more pertinent issue that's being emphasised at the moment, I'll just hand over to Julius to run his thoughts through that.
Thank you. Can I start by reiterating that apart from condition 2, which I'll comment on in a minute, the applicant fully supports the city's recommendation for approval and all of the proposed conditions. The main issue that's been raised by the objector really revolves around whether or not the application for development approval should have been signed by the owner of Lot 4. Now, an owner who believes their signature should be on an application for development approval will always have recourse to deal with that. But really the first part of our written outline of presentation that was filed deals with the fact that it's not something that really is a concern for the development assessment panel in its capacities in determining an application on the merits. The provisions of the DEEM provisions and the DAP regulations, in my view, make it abundantly clear that signatures on development applications are something that is expressly required to be considered at that initial stage of whether an application is accepted for assessment. It's not mentioned as a consideration for the purposes of determining an application for development approval on its merits once it has been accepted and assessed. So it is largely a storm in a teacup in terms of whether or not that application or that signature is required. As I say, it's something that the owner has recourse if they wish to pursue it, but they haven't to date, and it's not an issue that the DAP needs to determine for the purposes of dealing with the application. But further than that, the applicant has explained why, in this case, the development application does not need to be signed by the owner of Lot 4. And that comes down to the fact that the proposed development for which approval is being sought is not located on Lot 4. And that in turn is on the basis that any use and any works that are proposed in respect of Lot 4 are not development that requires approval. Now, in terms of the use for access, that is squarely and directly supported by the Tribunal's decision in Puma Energy, applying the High Court's decision in Lygon. Don't propose to say anything more about that. For the works that are proposed in respect of Lot 4, the same purposive approach to whether something constitutes development that was applied in Puma Energy and various other SAT decisions, including the Glenbrook decision, I think that was referred to in the objector's submission. Applying that purposive approach in respect of works as well as use, the works on the easement land are clearly of a nature that is entirely incidental and ancillary to the proposed service station and other developments on Lot 2. And they're purely to facilitate the access for Lot 2 from Lot 4, which it has as the existing easement rights. And it's a fundamental aspect of those easement rights. So having regard to those things and the nature of the works, we say that much in the same way as the use of the easement land for access isn't development that requires approval. Neither are the works development that requires development approval under a planning scheme. Now, as to whether or not the owner of Lot 4 nevertheless has to agree or consent in any way to the actual carrying out of the works, and that's really what we've heard a lot about from the objector's submission this morning, that depends entirely on a proper interpretation of the provisions of the easement. That again is not something that a development assessment panel, with all due respect, needs to deal with. That is a dispute, if it arises at all, between the applicant and the owner of Lot 4 under the terms of the easement. But the applicant's position, without going into great detail with it, because so I've been brought in at the last minute because Mr. Hodgkin was away in Europe, but the applicant's position is that the owner's agreement and consent is not required for the carrying out of the works that are proposed on Lot 4. Now, whether or not that's right, condition 2, as proposed, effectively seeks to override that and require the applicant to get the agreement or approval of the owner of Lot 4 for the works. Now, as a condition of development approval, that, with respect, simply is not valid because it relies upon and requires third-party approval as a condition of a development approval. And this very DAP, I think only last week, deleted an identical condition in near identical circumstances for a very similar type of development for exactly that reason. So we said that condition 2 should be deleted again for exactly the same reasons that the DAP deleted the same condition on the 24th of June for development on Wanneroo Road. I don't think if you indulge me, the very brief point I make, there's a lot of talk about whether or not the shopping centre approval would need to be amended to deal with car parking. There's plenty of case law around the extent to which when an actual application for development approval needs to be amended. Not every small change to an approved plan of development needs a new development approval to be amended. When we're simply talking about relocating a tree, and perhaps relocating or dealing with some car parking bays, we said that in context of this development for the shopping centre is not something that you would normally require a complete new application for development approval to deal with. It's a matter that will be well within the scope of the existing approval to be dealt with without the need for that. So we're happy to answer any further questions.
Questions, councillors? Councillor Huntley, Councillor Coetzee? No?
Not at this. I was going to say,
You're
is
on
there-
mute, Councillor Huntley. I can't hear you.
oh, can you hear me now?
Just come off mute.
Can you hear me
You've come
now?
off mute, but we still can't hear you.
You can't hear me.
No, you're on mute.
Off here. Right. Is that any better? Can you hear me now?
No, still no luck. We've got a bit of a problem there, Councillor Huntley.
Yeah.
We'll deal with questions from the other members of the panel. And now we may cover the questions you have.
Yeah. Okay.
Okay. Any panel questions? Member Hyde, go ahead, please.
Thank you. Similar, I suppose, to the way I started my questioning with the previous presenter. The earlier, if we like to say, the master plan approval or whatever, the detailed area planners showed those 2 access points to the east and the west of lot 2, one of which now provides access to Dan Murphy's, the other provides access to nothing very much. Did the applicant consider those points of access in the first instance for this development?
In the early stages, we looked at different scenarios, but just given the shape of, because the site's kind of shaped like a T, the top section of the site, with it being more narrow along the north, it lent itself to a more functional design with the service station on the western side and the car wash on the eastern side. So the proposed access points to Clayton Street would afford a more functional arrangement for the circulation of vehicles and the fuel tankers.
Right, it might provide more functional, but do those points of access, east and west, those crossovers work at all, or do they preclude the function of the site happening?
It would definitely require a redesign to utilise either of them. I think the western driveway would work quite well. I guess the issue with the eastern driveway is that it's also shared with a shopping centre car park. So being able to separate, those vehicular movements would be a good outcome as well.
Although we have heard from the previous presenter that there should be general rights to those points of crossover. And again, if we refer back to the overall plan, I think those areas to the south that we're talking about, shopping centre car park, was supposed to be temporary car parking and to be future mixed use sites, including some residential development. So it was assumed that of access. So thank you for that answer. You've raised the issue of deleting condition 2. I understand the reasoning behind that, but I wanted to ask your opinion if condition 2 were deleted. Condition 3 is still in place, which means that the approval recommended by the local government is only related to lot 2. What is your comment on that?
Well, I think that's consistent with the applicant's approach to this whole to the whole application, the elements that are proposed in relation to or in respect of lot 4. I mean, it's going to be used for access, and there is the crossovers that are proposed. But the applicant's position is that those works are not development that require approval.
I understand
Now
that.
that's why the application is framed the way it is, and that's why, in fact, I think we're happy with condition 3 because that reflects the way in which the applicant has always envisaged this matter proceeding. There may well be negotiations that still need to take place between the owner of lot 4 and the applicant. My instructions are somewhat contrary to what was indicated previously. There were ongoing negotiations. There certainly was a set of conditions were proposed by the owner of lot 4 for giving its consent, and there was a response made to those conditions, and there was nothing received back from that. That's where negotiations sort of stalled, but they were underway.
Okay, so what condition 3 would do then would be to, subject to the DAP's direction, but would only relate to lot 2 and nothing to do with lot 4 in all of its complexities. If you were unable to conclude those negotiations satisfactorily to reflect the plan that you put forward, which are 2 additional crossovers, shall we say, from Clayton Street, then you would be left, well, the risk would be that you would need to either redesign the access or rethink the application, and either through a Form 2 or a Form 1, subject to the significance of those changes. Would that be the case?
I think those would be the likely scenarios flowing out of it.
And it's no different in principle to what might occur within any number of commercial developments. There may be things that have to be negotiated with adjoining landowners that may or may not result in changes being made to the application. But again, this is something Mr. Hodgkins looked at in more detail than I have previously, but his view is very firmly, as I understand it, that under the terms of the easement, it's primarily an issue with the city in terms of the approval for locations of crossovers. The easement gives very broad rights.
Yeah, just one other question. Obviously, there's always been identified a right of access to Butler Avenue, which again seems to go over a car park over some distance to the south. What function does that have in servicing this development? Is there some legal obligation that petrol tankers have to access a site from a public road, or is there some legislation that hasn't been referred to in that respect?
Not necessarily. I'm not aware of any legislation that requires fuel tankers to take a particular route. I certainly don't think that service vehicles are precluded from utilising Clayton Street, for example, because I think there's plenty of examples of service vehicles already using that street to service other developments in the area. But because the site is effectively a T-shape and it has frontage to Butler Boulevard, that access leg is, and that it's simply there to ensure that firstly, the price of fuel can be displayed to passing motorists
On a public road.
But also the fact that, Butler Boulevard being the main east-west thoroughfare through the district centre, there's a capability for people to enter and exit from that road as well.
Okay, lovely, thank you for that.
Yes.
Yeah, I've got a number of questions for the applicant. And they relate to traffic and the fuel tankers and manoeuvring. Now, I've got the transport assessment, the traffic impact statement prepared by Transcorp for the applicant, the application, and I'm looking at the swept path. There's several sets. I don't really have much of an issue with regard to the smaller vehicle, which is just a medium rigid waste management vehicle. The swept path seems to be eminently reasonable in terms of the way that it's been portrayed into another side of the low loading bay, etc. I'll go to the worst case scenario, which is the fuel tankers, which the design vehicle here is 17.25, which is a relatively large fuel tanker. It's entering from the west and exiting to the east. So it's traveling from a section of Clayton Street, which is serving big boxy bulk goods showroom.
Just so we can, that's
correct, that one. It's labeled T 23.2.275 SK 04C.
Yep.
Would have been the third iteration of this swept path. Is there any reason it's traveling from this section of Clayton Street, coming into the site, doing sort of in forward gear maneuvering? The fuel tank, the underground fuel tanks are located right near the northern part of the site rather than well within inside the site like other petrol stations might be. And then it's exiting using a right hand movement into Clayton Street to travel east.
Yep.
Beyond what's shown on this figure, as Deputy Presiding Member Hyde has noted, that the street changes somewhat further east, approaching Exmouth. There's several actual formalized, unsignalized pedestrian crossings. There's parking on both sides. The Woolworths and the shopping center developments on the south side. There's probably a lot more traffic on approach to the train station. Am I to assume this is exiting at Exmouth at some point and going somewhere? Because I can't see anywhere in between.
Yeah. So it's got capability to exit from Camborne Parkway, which is the next intersection over, and it also can exit from Exmouth Drive. Importantly, there are other commercial developments along the eastern side of Clayton Street that utilise those roads already for service vehicle movements. In the Woolworths development, which is at the far eastern side, has a service area at its southeastern corner, and those service vehicles that service Woolworths utilise Exmouth Drive as well.
Okay, but my question was, the trucks, the path showed in the documented report appended to the agenda and the RER shows them originating from the west, destined to the east.
Right.
It's not showing originating from the west, somehow doing some 180-degree hairpin loop and going back out towards the Camborne. This is showing them going east along Clayton to some point, presumably Exmouth, because it's an
sorry, I got my words mixed up. So Camborne's on the western side. So before Exmouth Drive, there's another side street.
Another access leg on the easement.
Correct. Yeah.
Yeah, it's not an actual street. It's basically the western edge of the shopping centre.
It's a north-south.
Yeah. So the swept paths have been tested for those. It can traverse through that street, or it can traverse. I shouldn't use that.
But it's not documented in the report.
No, but we did provide the swept paths to the city for additional information.
But not as part of the attachments to the RER.
No.
So I can't make a judgment on that. Okay.
Sorry, the terms of the easement don't preclude trucks, fuel tankers or anything from using that?
Fuel tankers are service vehicles.
Okay, well, just ask that.
But that's not been documented in this report.
No, we provided that information through an additional information response to the city earlier in the year.
We can check that with the city.
We'll have to check that with
It hasn't found its way into our documentation.
I don't believe it's included in the RER.
No, it's not.
Okay, thank you. Okay.
All right, so my next question is, following on from Deputy Presiding Member Hyde's question, in relation to alternative access options. Again, my concern isn't so much with the waste management vehicle or any medium rigid, semi-rigid, smaller vehicle coming in and out, because it tends to come in one driveway, turn around on the site and then leave. Kind of comes from the west, goes to the west. Has it been, I appreciate we're talking about massing and design of the site, and it is an odd shaped site. It's shaped like an L with like a giant at the top, and it's got its northern boundary actually bounds lot 4 with the easement. But on the west, it actually bounds lot 101. Has there been a swept path or an alternative option tested from a swept path, a traffic engineering perspective, to come in via Butler Boulevard, which is a higher order road? It's a district distributor A, travel north, do what it does on the site, and then exit via the western boundary of lot 2, via the 101, via lot 101. Lot 101, this road or access is clearly being used for the Dan Murphys by similar sized vehicles, because their loading dock is actually located
on the northern side of the building.
Opposite this site, further to the southwest. So clearly, these types of trucks are comfortably using this particular crossover access way, whatever you want to call it, on lot 101 comfortably. So has that option actually been considered, as opposed to coming out directly onto Clayton Street, coming in via Butler Boulevard through the actual site, doing what it does on the property in terms of delivering fuel, and then somehow veering to the west and then exiting out via that access way to Clayton Street and turning left or right?
I can't recall if that specific option with that specific movement's been considered, but it looks like it's something that could work, just looking at it notionally.
I'm just looking in terms of distribution of risk and opportunity, all right? Coming in off a higher order road, I mean, we're not here to debate how it was subdivided. I think we all agree that it's interesting at the very least. At least it would be coming in on its own property and it'd have a right of access, and it would be in forward gear, and then it would do, and I'm sure there are engineering solutions here. And if there is an actual ongoing debate, dispute, disagreement, I am not a town planner, with regard to the utility of Clayton Street, otherwise known as Lot 4's easement or whatever, or public access way, and whether or not the parking needs to be taken out or not. I don't have a lot of concerns right now about the on-street parking being taken out from a utility use supply demand perspective, so I'm not going to comment on that. I'm just more interested, see if we can make this work to come in from one road and exit to an exit, a crossover on the adjacent lot to the west, which is not lot 4, which is clearly being used by similar vehicles and probably more on a far more frequent basis, because those are associated with retail commerce, and then turning out at this particular intersection on a Clayton Street. I'm not aware of any, bear in mind Clayton Street's not shown on the main roads database.
Member Hagan, do you have a question?
Yeah, okay, my point is, is that something that can be considered?
We can look at that for sure.
Okay, all right. Now, these are simpler questions. Has there been a crash analysis done on what is referred to as Clayton Street between Camborne and Exmouth? It doesn't appear to be documented in the report.
If it's not documented in the report, it probably wasn't done.
Okay. Has there been engagement with the owners of lot 101 to consider an alternative access scenario?
Not that I'm aware of, although if the public access easement applies to that portion of the lot that's already being used for access, I mean, I'm sure there would be some discussion with them, but you know, the easement would afford the access rights regardless.
Okay. So has this option, you probably answered it, been discussed, considered, chatted with the city of Wanneroo of planning officers, engineering officers, in terms of alternative access via Butler and lot 101?
Not specifically.
All right, those are all the questions that I have. Thank you.
Okay.
I suppose just to finish, to round off the answer to those questions, I suppose what this indicates is that the applicant's position is if it's applied for development approval for what it thinks it can achieve this, and it can be achieved. But if for any reason, you know, negotiations with lot 4 or anyone else break down and it turns out that it's not able to be achieved, there are certainly other options that can be explored. They may well require an amendment to this approval to change the locations of some aspects.
Don't have an approval yet.
Oh, got an amendment to this proposal, sorry.
Okay.
Jane, just want to see if Councillor Huntley.
Yes, Councillor Huntley, can we hear you now? Or
Can you hear me now?
yes, we can. Thank you.
Yes.
Have we answered your question?
Yes, you have. Yes, thank you, Deputy Member Hyde. That was brilliant. Yeah, you did. Caught it really well.
Thank you. Yeah, now I think we'll query the council whether they've got those swept paths just for reference purposes, but you did confirm that there's no restriction on heavy vehicles. In fact, the day I was there, Woolworths had a large vehicle moving down Clayton Street for servicing, and some of the other larger big box.
Correct. The point that I was trying to make on that is that Clayton Street's already being used by vehicles of a similar size. I know that Woolworths gets serviced by a 19-metre long semi-trailer, which is a bit longer than what we're using.
Yeah.
There's multiple commercial developments in the immediate area that are all using that exact, I don't want to use the term road network because it's not a road, but that private access way subject to a public access easement being used for that purpose.
Is, can you just reconfirm the vehicle numbers travelling along Clayton? Did you do
Existing or proposed?
Existing. No, I'm talking about current usage. Because when I was there, it looked very busy.
Okay. It's definitely in the traffic report.
Roughly, it doesn't have to.
There weren't any existing volumes along Clayton, but peak hour counts at the intersection of Camborne Parkway. Oh, it was about 5,800 vehicles at the intersection of Camborne Parkway and Clayton Street.
That's over a 24-hour period, or
yeah, per day, correct.
Okay, all right. That's not no further questions from me. So thank you very much for your presentation. We may query you.
One
we
other.
do have a late start.
So I have a late start, that's right. Just referring back to the traffic impact assessment, the work that was done suggests that it's a less than 10% impact on the road network. Now, does that take account of the query that Ms. Hergert's made about, how it enters and exits the site if it uses the east-west connector? Presumably this statement relates to those roads as well as the public easement road.
I would think so, yeah. The CIDRA in particular looked at the number of movements in and out of both of the crossovers, so I think that was well documented.
Okay, thank you. Thank you.
Okay, thank you. All right, well, we'll move into now discussions with council staff. And members wish to ask questions of Nick at all? Nick, did you want to make any specific comments on what you've heard to date in a broader context? There were some comments made
yes,
about
please.
things that have been lodged at council.
Yes, sorry, just as to sort of start maybe from the beginning, just quickly, just to outline the city's position. The recommended approvals is effectively only for the lot that the applicant owns. The condition that we applied was similar to a condition that we applied at the last DAP meeting for the service station on Wanneroo Road. Understandably so, the DAP resolved to remove that condition as they saw it as being an ultra virus condition or requiring the approval of a third party. The city does consider that the works on Clayton Street on that private road is in fact works and does in fact require a development application for the landowners to sign. The information that's been supplied to date surrounding traffic relies on those accesses being constructed. There is no further traffic information supplied to the city that would, I guess, detail alternate modes of access to either the other established crossovers onto Clayton Street or solely using the access leg to the south towards Butler Boulevard. So it's the city's view that if the condition 2 was removed from the approval, that it would not be approvable. However, I would suggest that we would be open to a deferral to allow the applicant to potentially amend their design and supply further traffic information to demonstrate that the accesses and traffic can work and all the swept paths can work without those accesses to Clayton Street to the north.
Okay, thank you. Just have a quick query regarding the comments that were made, and it probably covers all of us on this, is a comment was made that within the first 7 days of you having the application, you could have requested further information, namely the consent of the owners of Lot 4. Were you aware of that being required? And when you didn't have it, did you not contemplate stopping dealing with the application until you got that?
I wasn't involved directly with the application at that point. However, my understanding is that it was requested after the application was accepted, and that the application was decided to continue to be progressed on the presumption that I guess the owners would enter into would sign the application forms for lot 4, and then it was progressed further on the assumption that the applicant would progress the application without that consent. I do believe that the city requested the further information relating to traffic without those access points, which wasn't provided, which has resulted in the recommendation before you.
Okay, and just quickly, the swept path plans for vehicles moving further east through the easement areas?
I did have a look at our system and the request for information. There is a submission from Apex Planning, the applicants, demonstrating that there is swept paths of the service vehicles, swept paths moving east-west. The swept paths actually detail it moving right to the end to Exmouth Drive and making a southward turn along Exmouth Drive, which our traffic services team has reviewed and were found acceptable.
Unacceptable, did you say?
No, acceptable.
Thank you.
Acceptable.
Okay, all right. Well, I've asked my questions. Now, councillors, do you have any questions of Nick, please? No?
Not at this stage.
Okay, panel members? Yes. Member
Quick
Herc?
one, in relation to the swept paths as shown in the RER, which have them coming in from the west and then exiting to the east. Did the city request the reverse movement using the crossover arrangement as proposed in their plan that was submitted to the city to come in from the east and exit to the west?
I don't believe that we have swept paths for the from an east-west movement. We only have it from west to east.
Thank you.
Okay. Yes, Member Hyde.
Thank you. Couple of questions for you. What I think you were alluding to when you said when you were talking about the removal of condition 2, that would presume that perhaps the applicant could do a number of things. One, they could continue with their negotiations with the owners of lot 4 or its representatives and submit a separate application for those works, should it be deemed necessary and signed by the owners of lot 4 to allow for access to this development. Or I suppose they could come forward with some alternate plans. What would be the benefit of your suggestion to defer if those negotiations with the owners of lot 4 were to come to some meaningful arrangement? Just assuming that, and sorry, as a second part to the question, I don't see a time frame mentioned in the preamble, which would normally be for a period of 4 years. So that's quite a period to allow for those sorts of things to occur.
I think that the purpose of the deferral would allow the city to be able to review updated traffic information to demonstrate that the access and internal circulation of the site could work. At the moment, the access and internal circulation relies on those access points and shows that those access points work, and that's fine, but there isn't any information to show that sole access effectively from the south would work. So the deferral would allow the applicant to update their traffic reporting to demonstrate that.
Okay. And if the panel's view was that they wish to approve it today, where would a substantial commencement time frame sit in your view? Because we don't have any advice notes either, do we?
No, I don't believe there is any advice notes for this. I believe the regs say there is a
default.
Default, yes, which would be what you would rely on if there was nothing in the conditions of approval.
Well, I can't see anything in the conditions. Would it be the
No.
the city's preference to have something clearly in the conditions, or just to rely upon a default through the regs?
I believe that the default would be satisfactory in this
All
instance.
right. Okay, thank you.
Just to clarify, what is the default?
4 years.
It's 4 years.
Yes, yeah.
Just so that others that maybe.
It's in the DAP regs too.
Yeah.
Yeah, okay, sorry. And just also there seems to be some suggestion, I think, in the RAR that the city doesn't have any rights as, if you like, an authority to allow for crossovers on this public access way, other than what has been previously shown in a past approval. Do you agree with that? Is that your position? And does the city not require crossover permits and those sorts of things, or does it happen purely through agreements between landowners and development approvals?
The city does require permits for crossovers onto city-owned land,
Right.
but not between the, I guess, Clayton Street and the subject site, being that Clayton Street is held in private ownership.
Okay. Did the city have any other concerns about those crossovers as shown on the application with regard to the street tree and the removal of parallel parking bays?
No, my understanding is that the crossovers, as assessed by traffic, the traffic team we were satisfied that the crossovers would accommodate the vehicular movers as shown on the traffic reporting. The vehicular bays being removed was also not considered to be, I guess, an issue to preclude the application from being approved. However, noting that the application, the works in Lot 4 would also require development approval.
Yes.
Going forward.
Yes, I understand that. So that's where we were talking about 2 separate approvals. I think that was my understanding of what you were saying. What is your understanding of the status of the detailed area plan or local development plan, as it's more known these days, that was attached to the first presenter's submission?
What do you mean by status? Is in its weight?
No, just was it just put forward by the applicant? Was it endorsed in terms of the planning framework? Well, yes, you could say weight if you like, but status is, I think, a better word.
The area plan submitted by the applicant isn't signed.
Not the applicant, by the first presenter,
yes,
inter alia.
The one that's been submitted by the presenter isn't signed, but I believe, and let me just double check for you. I'm just going to pull the city's DAP up.
My reason for asking is that the RAR talks about the structure plan, but
yes,
a lot has changed since the structure plan, both in terms of, what was to be regarded as Main Street, which was to be north-south parallel to the railway, what was to be regarded as the characteristics of this east-west connector, and, even the context of Precinct A. So I just wondered, has that actually been characterised more recently in terms of detailed area planning, or how does the city assess those things in the planning framework context?
Well, in this case, the structure plan is obviously a due regard document. It's quite a well progressed structure plan area, and its character has changed over time. The city's assessing officer looked at the character of the area and looked at the application, considered that it satisfied the relevant provisions, and was satisfied that it could be approved on its merits under the structure plan. The local development plan provided in the submission isn't signed, and it isn't mentioned obviously in the reporting. So there was no weight given to this submitted.
Okay. Thank you very much. I don't think I've got any other questions, presiding member. Thank you.
Okay, thank you. Well, if there's no further questions of either of the presenters, we can move on to the next item on the agenda, and that is for the panel to discuss the application. Sorry, did I hear someone? No?
I put my glass down.
Okay. All right, in order to do that, we need a mover and seconder for the responsible authority recommendation. Do I have a mover?
I'll move for the purpose of putting it on the
Okay.
table for discussion, presiding member.
Member Hyde. Do I have a seconder?
Councillor Huntley.
Councillor Huntley, yes, thank you,
Yeah.
councillor. All right, yes, member Hyde, if you'd like to speak to the item.
It's a very difficult one. There's been a lot of opinions put forward from applicants and objectors, many of which are quite conflicting. But what I take from the responsible authority report and also from the discussions that we've had this morning is that there is the land uses and the locations of those land uses that are proposed, that being the service station and the motor vehicle wash, and the built form that's being proposed, are generally acceptable. The issue seems to occur from access. I think when I look at what has been assumed by some, that the access should all be from Butler Boulevard, I find that to be quite unreasonable, and I think there must be alternate means of accessing Lot 2 in order to create an acceptable form of development that responds well to Clayton Street and the centre as a whole. I think the danger of not providing some means of access either directly from Clayton Street or from alternate side streets, as the case may be, or access points, as the case may be, would cause any development on this lot to present its back of house to Clayton Street, which I think would be a poor outcome. And clearly the area has changed over time since the point of the structure plan preparation, and we've heard that there is limited weight, if any, applied to the detailed area plan. And I think there are a number of other large stores relying upon large vehicles to service them, and they're predominantly car-dominated uses. Indeed, the main street, as was referred to by some, has quite a different character on this east-west connector as it does nearer the station, and therefore the emphasis on pedestrian priority is quite different. These uses rely very much upon traffic, and therefore that is a considerable function of Clayton Street at this location. I think the removal of, potentially the removal of some parking spaces, a light pole, and a tree are not significant matters, noting that the street tree is not necessarily thriving in this location at the moment. However, increasing the number of crossovers is generally not a good planning outcome if other alternate points of access exist. I think that it's quite clear, however, from all of the discussion that at this point we are uncertain about the role that Lot 4 would play in this development. I do understand and do believe that the easement does not grant full powers to the local government to make changes under its own discretion to Clayton Street. And I do think that there would need to be a further application with the agreement from Lot 4 to provide the access points as shown. That hasn't been forthcoming at this point, and therefore I think that we only have the ability to approve development upon lot 2 and concur with the local government that that is what is said in condition 3. I am concerned about the validity of condition 2 as it requires third party approval beyond this process. And therefore, presiding member, I would propose an amendment to delete condition 2 and renumber accordingly.
Okay, so that's an amending motion you're putting forward at this stage. In order for that to proceed, you're moving that. I will require a seconder to that amending motion. In the absence of a second, I'll second it. You can speak to it.
I think I already have, so I don't think I need to say anything
Thank you.
more.
No, I think that it's all the presenters have generally agreed that that is the case. So unless any other panel members wish to speak to the amending motion to delete condition 2 on the agenda, is there anyone wishing to speak to that? Councillors?
I'm just, so if we delete condition 2, so ultimately we are taking away the fact that they need permission from lot 4's ownership to build those crossovers. Does that mean they would get access to build those crossovers or not?
With condition 2, it's fairly clear that if we were to delete condition 2, condition 3 still stands, and all we're doing is taking away a condition that we don't have the power to impose because it involves a third party.
And so condition 3 does mean that technically they've got no way out at the moment. They're just literally, we're passing it with no way out.
We're not saying that because we don't, it's not up to us to determine that under the terms of the easement. It's the beneficiaries of the easement can argue that out later on.
Absolutely. So they do that through their negotiation.
Yes. Okay.
I think one way to look at this in terms of my right of reply is as potentially a stage to development, that what we're approving at this point are the land uses, a particular configuration to those land uses, but at a time that the applicant is unable to provide the access that they prefer at this point to this development proposal on lot 2, then they have the option either to allow the approval to lapse or to seek alternate configurations to provide access and all the necessary technical documentation that supports that. And subject to the assessment at the point, should an alternate be provided, the level of significance of those changes, then an application could either come back as a Form 2 or a Form 1, or indeed as a separate application which provides for access only.
Okay. All right, having said that.
Just to come back to me, if I may, just I had considered the matter of deferral, but given the amount of time that has lapsed anyway, I'm not sure at this point that a deferral would serve any particular purpose. But if other members are mindful to defer it, I'm very happy to listen to that debate.
Okay, well, I think we need to vote on the amending motion as well.
Oh, sorry, did I not?
Okay,
Did I?
no. Okay, so I'll put the motion to delete condition 2. All those in favour? That's unanimous. Thank you very much. And you have completed your...
I have, sorry, presiding member.
Okay, so councillor Huntley, you have got as seconder right to speak on the matter.
Yeah, thank you, presiding member. I have an issue with this because I know when this initially came up that this was supposed to be a walk through, a town centre walk through. The built form was delivered here so that in 50 years, if it should ever need to be adapted for residential use because of the train line being so close, then ultimately all these buildings could just be knocked down, cleared, and off it goes again. However, if we allow, or if there is an allowance with now another further 2 crossovers, it sort of does make a mockery of what the original idea and forethought this had when there's already 2 crossovers there. So I would actually, I'm in favour of the development, but using the alternate crossovers, using the crossovers that are here, because I cannot, a simple redesign can make this work. They'll have 3 access points if they want it, and the little tree and the town centre image that was actually evolved for this stays the same. And once that's built, then there's nothing else to come in here, apart from there is a little bit of space on the next lot, but obviously they've got access from 2 areas anyway, so they're not going to need another crossover into Clayton Street. So I would actually I would support a deferral to redesign this and to bring it off the crossovers that are actually there. And that's simple. I think a redesign actually would actually look quite suitable, and it wouldn't squash the car wash so close into the Woolworths car park either. So I think and to access it from Woolworths car park really is probably an opportunity for, like, come and wash your car while you go shopping or whatever. It's probably a better way to have an opportunity for people to cross over at that point rather than through the 2 exits of Clayton Street. I can see that would be a problem with Clayton Street. I would actually prefer to go to deferral, but if not, I would support this with the crossovers being where they're existing.
We just missed a little bit there because the screen went blank here, Councillor Huntley, but I'm pretty sure we, if you could just go back maybe a minute ago.
Okay, so I would support a deferral. I think a deferral just for them to do a quick redesign and to actually not worry about lot 4 at all, just come out on the 2 crossovers would be a simple fix. And they could do that really quickly, so that it shouldn't defer it for too long, certainly not more than 3 months. If we do approve, I would prefer to approve it with those access points off the 2 existing crossovers rather than create another 2. So.
Okay, are you foreshadowing that would be an amending or procedural motion, wouldn't it?
No, I think it's procedural, isn't it?
Yes.
Procedural deferment.
Well, if you wanted to move a procedural moment to defer the application, you've mentioned why.
Councillor Huntley would also have the option of doing that after.
Yes, I think we can debate the issue at hand now, and then you've still got the option later to come back to move a procedural motion.
Yeah, I'm happy with that.
Discussion about what's before us at the moment. I do get nervous redesigning applications that are before us. I don't think that's our role, to be honest. But anyway, anyone else wish to speak to the item? Councillor Coetzee? We've lost you now.
Sorry, can you hear me now?
We can hear you and see you. If you don't touch your screen, we'll be all right.
Okay, I have to swap my iPad the whole time, every time to just touch the speaker.
Okay.
I actually would also like to defer it, to be honest with you. I wouldn't say really for a redesign. I would only say maybe for to show an adequate access that's not demonstrated on this agenda or application for me myself. So that's where I will leave that for now.
Okay, thank you. Member Higgett?
I don't have any concerns in terms of the land use, the appropriateness of this particular type of activity in this part of the general Butler precinct. It's appropriate. It's not dissimilar to a number of other generators in the area. You know, related to that in terms of traffic generation, not overly concerned about that too. This type of use tends to generate a lot of most of its traffic from passing trades. So the net difference to the road network that's currently operating is minimal, and it's not going to introduce additional risk into the profile of the access easement or the surrounding public road network. I do have concerns about entry and exit by tankers. The plan as it presents now, I'm not satisfied that the larger fuel tankers delivering to the site based on the origin destination as presented in this report adequately show that it's a safe maneuver, particularly on exiting, coming from the west going to the east. Seems to hit the building across the street, which is why I asked whether or not the reverse movement was considered. I'd like to think that that would be actually a movement, oops, items disappeared, that potentially would have less of an impact on built form on the north side in the context of the access arrangements presented. Having said that, I would support deferral as well to consider potentially other access options. In addition to the one that I mentioned earlier in the discussion this morning, you know, potentially a combination of entering via Butler and perhaps having one access to Clayton Street for exiting purposes towards Camborne Parkway. That takes out concerns that I have in terms of the eastern part of Clayton Street, which is very pedestrianized. It has a formal pedestrian crossings, which were approved by Main Roads and implemented by the city of Wanneroo, or probably the subdivider in this particular instance. And the fact that there's a lot of cross friction there. So I would actually support deferral at this stage to go back and look at alternate access arrangements. In terms of use, no issue with that. In terms of traffic generation, again, I don't have an issue with that either.
Okay, thank you. I will put my two bobs worth in. I think the application is well presented. I think the use is one which is contemplated in the structure planning, the Butler District Structure Plan. There are uses that are proposed, and these uses are discretionary. The architectural drawings that have been submitted, the built form, does take account of keeping built form away from the street, Clayton Street as we call it, and trying to keep an open field to that street rather than a built-up form. But I don't think a service station and car wash is going to present as a main street development in any event, because it's highly car orientated, and like all the other areas that where the uses are and access to uses on the northern side, the areas are paved and used for vehicle access. The traffic report that's been provided, in my opinion, and it hasn't been, and it's been supported by the council, the swept path analysis works. I'll take that on board. I'm not a traffic engineer, therefore I'll take into account that that has happened, and I'll take into account also that the city's officer at the meeting today confirmed that vehicles heading east onto Exmouth, is it? Can in fact turn into the swept path analysis is designed and shown as working based on this particular configuration and how the applicants want to have their delivery vehicles, and I'm sure they'll instruct their drivers to approach from the west and leave from the east, or go to the east, or where they can exit back towards the west, because a lot of the vehicles will come into the site, back into loading bays, and then leave by going to the west, not to the east through the finer grained land use where they've got pedestrian orientated town square. The issue of the odours and noise, etc., that generally come along with service stations have been addressed through an acoustics report and comment through the application that odours are generally assessed for sensitive land uses through the process of the Department of Mine Industry Regulation and Safety, where the applicants have to provide risk assessments for sensitive land uses in the locality. From my point of view, the deferral of the application I wouldn't favour. I don't think it's our role to redesign these sorts of applications before us. We've got an application to determine. We can defer it. I don't think asking the applicants to come up with alternative designs that rely once again on the owners of Lot 4 and also the owners of Lot 100 on the western side. We don't know how these owners are going to respond to any application. We have an application before us to determine, and we know what the issues are with this one, and that is that there are some access arrangements that adjoining owners are not favouring, and I think we either have to approve this and let the legalities find their way, or refuse it and let the appeals process take over and maybe flesh out the legalities at the same time. So from my point of view, I'm supporting the application as is, and close there and give the right of reply now to the mover.
Thank you, Mr. Coulthurst. Having listened to everybody, I can understand why there may be thoughts that a deferral would enable alternate designs. However, I think that process can occur on the basis of whether we approve the matter today and it be isolated to Lot 2, and thereby require the applicant to come forward with an appropriate means of access, and whether that be a corresponding new application or an amendment to the current application, that process exists for them, or indeed, as the presiding member has said, if they are not comfortable with the decision today, they have a means of recourse through the State Administrative Tribunal. But certainly, having removed the condition 2, we are now solely, as per the RAR, putting our determination only upon Lot 2 and allowing the applicant to come up with a means of supporting that approval in whichever way they see through the planning framework, through the planning processes. So I'm comfortable to support the application, and don't believe that a deferral will necessarily encourage alternates that couldn't in any case happen through corresponding stages post approval.
Thank you. That being the case, I'll put the recommendation as amended with the deletion of condition 2 and subsequent renumbering of all other conditions. All those in favour?
Can I move that a deferment?
You can move a deferment, yes.
Yeah, I think
Motion.
I'd like to move the deferment, because one of the things we haven't considered is that they have done some traffic work with regard to exiting elsewhere rather than from lot 4. I do think historically, and we are not, we're not taking the historical view into consideration, which I think we should be doing, which that was a town centre walkway, and we're now going to put 2 extra crossovers, or the possibility of 2 extra crossovers into that.
Sorry, you can't debate it. You can move a procedural motion.
Sorry. So yes, I'd move.
We'll need a second. So you're moving a procedural motion to defer,
deferment for 3 months.
and the reasons?
The reasons are to investigate the ability to use existing crossovers rather than create 2 more.
You mean access from the easements afforded from the existing crossovers from Clayton Street?
On Clayton Street, yeah.
Yes. Existing crossovers rather than existing. Did you get that? Not quite.
Up to the period of 90 days.
Okay, so if I can get the wording going, to investigate alternate access to the proposed development from the easements adjacent to the
either side of lot 2,
eastern and western boundaries of lot 2. Does that explain it?
Yeah, and that does give them then 3 months if they want to negotiate with lot 4, but they now have an opportunity to negotiate with someone else if lot 4's a no. So I think that's an appropriate thing to do at this stage.
Might be a no from the alternate access points as well. That's the issue I was raising.
Well, they're going to get that anyway, even if we approve it.
That's true. It's from the existing. Sorry, you.
Yeah, just from the existing crossovers, I think Councillor Huntley said.
From the existing crossovers to the easements adjacent to the eastern and western boundaries. Okay. Investigate alternate for a period of not up to 90 days. Up to 90 days to investigate alternate access to the proposed development from the existing crossovers on Clayton Street, if we can use that word. From the easements adjacent to the eastern and western boundaries of lot 2.
Yeah, happy with that.
Okay. So, Nick, does that give you enough time? I mean, it depends on how long it'll take them to come back to you, but then you'll have to assess them and do another R.
Yes, that'll be plenty of time. I guess as long as we receive the information within a reasonable timeframe, perhaps within 30 days, we should have plenty of time to be able to facilitate that.
Well, we'll say 90 days at this point, but if it requires further, then they can come back at that time. Okay. All right, so that's the procedural motion to defer. You've moved that. Do I have a seconder? Councillor Coetzee. Sorry, Heidi, I didn't quite see you.
It's all right, go ahead.
Okay, you can now speak to it, Councillor Huntley. Do we need to speak to it?
Well, I don't think I need to speak to it anymore. I think we know where we're at with this.
All right, well then I'll put the procedural motion recommendation. All those in favour? Against? It's carried. Okay. All right, well, we'll move on to the next item on the agenda. Back to that. Item 4, Form 2 DAP applications, there are none. Item 5, Section 31 reconsideration, there are none. Part C of the agenda, set application for Supreme Court Appeals. The only one we've got at the moment is the City of Gosnells. And item 2 on Part C is meeting closure. We closed the meeting at 11:15 a.m. Thank you, councillors. Thank you, presenters. Thank you, Nick. Thank you, fellow panel members, and